All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. We are on the record in CV21-0196. SAAD v. SHINOHARA. I'm sure I didn't say either of those exactly right. A couple of housekeeping items before we get started. Please remember these proceedings are being video and audio recorded and live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock, and there's a clock there in that center podium, to reserve a portion of that time for rebuttal if desired. Also, please keep in mind that we've read the briefs and have conferenced the case this morning. And with that, counsel, you may proceed.
May it please the court and counsel, my name is Daniel Torrens. I am the attorney for defendant Elizabeth SHINOHARA. Ms. SHINOHARA is in the courtroom with us today. Seated beside me is co-counsel in the case, Chris Robbins.
Be seated, ma'am.
Excuse me?
Your client was standing. I just
Oh,
told her
I'm
she
sorry.
could have a seat.
I couldn't see her.
That's okay.
I have to stand. You don't have to stand. Your Honor, to the extent that a procedural case can be tied to some form of literature, I offer to you that Shakespeare wrote in Romeo and Juliet, two houses alike in nature. This case involves a family dispute that does not involve defendant SHINOHARA, who is not a member of that family. In addition, this case involves two themes. The first theme of which is simply the rules that apply to civil cases and the record. So the rules and the record. The second theme is simply the fact that this case at the civil level involved two different tracks. Obviously, the court's indicated that you've read the material, so I won't regurgitate from the briefings the issues with respect to the civil dispute. But what is undisputed in this case, Your Honor, is that the trial court committed reversible error by dismissing this case as to defendant SHINOHARA when there was never an order of dismissal that applied to defendant SHINOHARA. So a little factual backdrop is in order.
So what do we do with the fact that each order that says the case is on the dismissal calendar never references SHINOHARA?
Well, I respectfully disagree, Judge Gass, because the issue in this case is the original track one of this case explicitly stated that the dismissal did not apply to defendant SHINOHARA. Those were the settlement conference judge's words as part of that order. Thus, we go to two separate tracks. As indicated in the briefing, that first track, the non-SHINOHARA defendants, proceeded through a number of extensions on the dismissal calendar, which were executed with stipulations never signed by myself as counsel for defendant SHINOHARA. Instead,
Let's come back though. The order's all set then. Shouldn't, at a minimum, your client have stepped in and say, wait, to the extent there's any ambiguity here, these orders are saying the whole case is on the dismissal calendar, isn't it?
well, respectfully, Your Honor, understanding the timeline here, we had a separate scheduling order. And I think it's a key point here to understand that when the initial dismissal orders were in place, much later, a second scheduling order was issued by the trial court judge. It is very clear by review of the record that there were two separate tracks, and that SHINOHARA is never identified as being part of any order of dismissal pending in the case. I think implicit in your argument, Judge Gass, is the question of... I'm sorry, I argue, you question. Implicit in your argument, Judge Gass, is a question I think I would ask myself in your position, which is simply, well, Mr. Torrens, you saw this minute entry come through. Why didn't you do something? And the answer is simply, we did do something, Your Honor. We reviewed the rules and we reviewed the record. And the rules in this case indicate that an order of dismissal cannot be self-executing. And when you track those dismissal entry orders, they clearly never apply to defendant SHINOHARA. She is never named in one of those. It is only after the fact and after what purportedly is, from the trial court's now perspective, that the dismissal in July 2020 applied to everyone, SHINOHARA didn't believe it, And certainly the plaintiffs didn't believe it, because in September, 60 days after that dismissal minute entry from Judge Thomason, it is the SAADs who filed a motion to continue on the inactive calendar yet again. So that is the issue in this case. When I talked originally about those two separate tracks, when we look at the record in this case, as we briefed in the timeline in our opening brief, it is clear.
So go back, what was the September filing again?
In September of 2020, and remember this is after what plaintiff now claims to be a dismissal, is a filing by the plaintiffs, not the defendant, asking for yet another continuation on the motion to continue. And I think it's important.
That's not a, but it again, does it specifically reference Shinohara, or is it like the subsequent?
It does when we look back at the beginning, that original first track.
But I'm talking about on its face. Let's just, and I'm just trying to understand.
No, I understand.
The September one
Yeah.
didn't mention Shinohara.
Well, but understanding that the original entry only references
I'm talking
Shinohara.
about just the four corners of that document.
Well, and
And I'm not trying to trick you.
No.
I need to make sure I'm clear. It like several of them didn't mention Shinohara.
I guess I'm not entirely following the question, Your Honor. I apologize.
We'll walk through the time.
Yes.
We've got Shinohara is expressly excluded.
Correct.
By the settlement judge.
Correct.
The next continuation, a paragraph and a footnote say Shinohara is not a party. The next one, it's just in a footnote. But then after that, including the September one, none of them mention Shinohara.
Well, I think I understand what you're saying here, Your Honor, but we have to start from the beginning.
No, but I'm just asking you, please, yes or no. It does not expressly say.
Well, that would be correct, Your Honor.
Okay.
It is not expressly. Oh, no. It is not expressed in that minute entry that Shinohara is named by reference. But certainly an understanding of the case record at the trial court level, it was clear. Because in this case, there were multiple settlement conferences between the parties, and it took over a year for the non-Shinohara defendants to resolve their case, hence the continuations. In fact,
Now my question.
okay.
Does it matter that it's not self-executing? Or if it's self-executing, because if I read it to be self-executing, can you still win?
Well, Your Honor, going back to my theme of the rules, it is not self-executing. An order of dismissal is clear that we need something more, and that's essentially the second part of our argument here, which is...
Is that you need it as to Shinohara?
Correct.
Or need it as to all the people?
Need it as to Shinohara.
Okay, so you're not, the dismissal, you would concede the rule with the other folks, with the SAAD defendants, as if it would be self-executing.
I guess understanding the law, Your Honor, I would have expected an order of dismissal for the SAAD defendants. Those are our rules. So whether those parties decided to do anything with it or not was up to the parties. Whether the trial court wanted to do anything with it or not was up to the trial court. In Shinohara's case, it's specifically clear what those two tracks were designed to do and precisely what happened when the Shinohara request for a status conference and ultimately the trial court essentially saying, well, Shinohara, you're too late. We're not going to let you apply for attorney's fees because this acted as a dismissal. We believe the trial court created reversible error by doing that.
So am I correct, the request for the status conference was timely based on the scheduling order?
I believe you're so, Your Honor, because if it's not clear from the materials, what you should understand is there was actually another date later that was not vacated by the trial court judge that we were supposed to attend. The purpose of the status conference request filed by defendant Shinohara in the case was to alert the court that we have some issues we need to address in advance of that hearing so that the trial court judge could be prepared. That's the reason for that status conference. And at which point the SAAD's objector saying, wait, oh, now the case is dismissed, which had never been raised before and certainly isn't consistent with a lack of order of dismissal by the trial court, which is required.
Is there anything in the record that the parties did anything under that scheduling order?
Looking back, what had happened previously, Your Honor, was that defendant Shinohara had filed notices of deposition that were to take place in May. There were some discussions about having settlement discussions. Defendant Shinohara did not want to go back to a settlement conference.
That's not in the record, is it?
No, Your Honor, it's not.
There's nothing in the record that shows.
We do talk in the record, Your Honors, about the settlement negotiations, and I think it's salient to this point. Activities were happening, communications were happening between counsel, and our records do specifically reflect that they were ignored. We do know, as I indicated previously, that the SAAD family filed a motion to continue on an active calendar. And I think the more salient point, Your Honor, is that orders of dismissal don't really apply to defendants. They're designed to penalize plaintiffs for not prosecuting their case. If defendant SHINOHARA doesn't prosecute her case, she wins. She gets an order of dismissal. At that point, she's required to file an application for attorney's fees. And certainly that's the issue here, because that order of dismissal never came. And the order of dismissal is required by our rules. Let's talk just a little bit more, because I think I've identified, some of the questions here, and with respect to Judge Gass, your questions with respect to the four corners of the document. I think it's important to point out the irregular procedural history that happened here as well with respect to how ultimately the trial court attempted to terminate this case. Realized that what the trial court did with the minute entry earlier this year, basically saying the case is over as to everybody, entered Rule 54C language. As we know, Rule 54C language wouldn't apply to defendant SHINOHARA because there wasn't a motion for summary judgment that was ruled upon. There wasn't a default judgment that was ruled upon. There wasn't any sort of metric that applied that would justify Rule 54C language. And as soon as the trial court entered that language, then obviously the only recourse left to SHINOHARA was to file the motion of reconsideration that was done, and then when that ultimately failed, we filed a notice of appeal.
Didn't that sort of in order your client's benefit at a minimum, because otherwise what would you have filed an appeal for?
Well, that's probably true, Your Honor, and certainly the trial court judge had a number of mechanisms available to it to try to resolve this case. The issue in our case, going back to the rules and the record, the rules do not allow the trial court to do what the trial court did.
So now let me ask you this. Let's say we agree with you. You're right. What do we do with the case? Doesn't it go back for the trial court to say, okay, fine, then the SAAD's claims against SHINOHARA are still alive? The trial court could certainly put a new scheduling order in place. A lot of discretion happens at that point.
Correct, Your Honor. We agree that the trial court does not have, not that I would ever tell what a trial court could or could not do, but our interpretation of Arizona laws, the trial court could not go back and say, enter a judgment in favor of SHINOHARA. The appropriate mechanism would be to remand this case back to the trial court, and at that point, the parties would have obligations to the trial court and certain options available to them that they do not have at the Court of Appeals.
But that's just it. We are not saying, okay, the only claim alive is SHINOHARA's claim for attorney's fees. The case goes back
Correct.
to the live case.
We 100% agree, Your Honor. The case simply gets remanded back to the trial court for further handling.
Okay.
I had intended to reserve 5 minutes, Your Honors, but unless you have any questions right now, I'll keep it at 7:50 and change and reserve the rest of my time for rebuttal. Thank you.
Thank you. Counsel, go ahead.
May it please the court, my name is Catherine Connor with Connor Law. I'm appearing on behalf of the group of plaintiffs, which included Plaintiff Mehta SAAD and intervener plaintiffs Ali, Nimmer, and Shahira SAAD. The first thing that I think is important to point out to the court, and you read it in our briefing, is that this was not a frivolous claim. In fact, the complaint survived a motion to dismiss, stated 13 claims against Miss SHINOHARA, of which 11 survived the motion to dismiss. 2 were allowed to be amended. They were amended, and an amended complaint with the intervener claims, also containing 3 claims against Miss SHINOHARA, were filed, and she answered.
Ms. Connor, why do the merits of the underlying claim matter to us?
I think they matter to you a lot because in the various cases the opposing counsel has cited to you under the old uniform rules, you need to look at, what was going on in the underlying proceedings. Was there a meritorious claim? That was one of the cases spoke to that. Other cases spoke to, was there action? going on by the
reason I'm
parties.
asking or a little perplexed by your arguments because the meritorious claim is usually a basis upon which to find that dismissal wasn't appropriate, that the court shouldn't have dismissed the case.
I understand the argument was made by opposing counsel that this was a meritless claim throughout, and therefore, I guess, suggesting that an attorney's fees award is justified, and we're disputing that. This is a meritorious claim. It has been dismissed.
But that's not the case, that's not before us. What we're really
No.
at is just the procedure. So I
That
don't
is
know if we
absolutely
need to go
correct.
into that at all. So
That's fine.
When do you take, what's your position, your client's position, I guess I should say, of when Shinohara's case, your client's case against Shinohara, went on the dismissal calendar? What date?
It went on the dismissal calendar in November of 2019, when Judge Thomason signed an order putting it on the dismissal calendar to January 22, 2020.
And after that date, your clients, both of them, one filed an amended complaint and one filed a complaint to which Shinohara answered. Shinohara filed an answer to the amended complaint on 12/27, and on January 27th, I believe, she entered the interveners.
I believe that. I believe your timing is correct, Your Honor.
So
Yes.
after you're saying she was on the dismissal calendar,
Yeah.
she filed an answer.
Based upon the court's order, you asked me about
Right.
what was the status. She was on the dismissal calendar at the time those things occurred.
And so
Yes.
those two things happened. How does one get off the dismissal calendar?
Well, I think that the way you get off the dismissal calendar is, in the old rules, you had to do the motion to, the list of witnesses and exhibits, motion to set. Under the new rules, you have to do the 16B scheduling order. In this case, that was done.
And so that's my
But-
point. So
Yes.
she originally went on in November.
Correct.
There's a joint report come March, and
March.
there's a scheduling order. So she, at that point, would be off the dismissal calendar, right?
She would be, but there was then another signed order in which the case, the matter, no exclusion from Ms. Shinohara, the matter was placed on,
Your clients all along were saying, and this is troublesome to me. I've got the order saying Ms. Shinohara is not a part of the claim settlement, Judge. I have a stipulation that does not include Ms. Shinohara expressly. There's a paragraph, subparagraph E, and there's a footnote. And then there's another one that comes in that's just a footnote. And then there's ones that don't include her. Was that an intentional effort to put her on a dismissal calendar, or how did that happen?
the stipulations were an attempt to update the court regarding the status of the settlement efforts between the settling parties,
Right.
which excluded Ms. Shinohara. So they were what they
So they were never
state.
intended to include Ms. Shinohara.
We were not reporting to the court about Ms. Shinohara.
So if the court simply signed the order that you submitted, then how was that order going to include Ms. Shinohara? Because the court said it was continuing the dismissal calendar. And that's continuing all the way back to November, and that means it's continuing the dismissal excluding Shinohara. How do I make the...
The way you make the leap is by the language. Judge Whitten entered a minute entry order placing the matter on the dismissal calendar as to all defendants and all parties except Shinohara. All of the subsequent orders that were signed by the trial judge said the matter is placed on the inactive
It said
calendar.
continued.
I'm sorry.
It
I'm
said
sorry.
continued.
Yeah, yes, continued on the dismissal, and I said
There's never a
inactive.
separate order that says, we're now placing this entire matter. It just says, we're continuing this matter.
Absolutely correct, and I apologize because I said inactive. It's dismissal calendar. So every single order continued the matter on the dismissal calendar.
But that's not in compliance with the rules, especially once I have a joint report and a scheduling order. Because that takes the case by the rule and the definition, plain language, off of the dismissal calendar. So how does the court turn around and in March 23 take it off the dismissal calendar with the joint report, and by your terms, in continuing the case on the dismissal calendar, which would have excluded Shinohara,
Yes.
put it back on with an order less than a month later,
I
or just
think
slightly over a month later?
the answer is twofold. Number one, the order said the matter. That was what was continued on the dismissal calendar repeatedly. To your point earlier, to opposing counsel, Ms. Shinohara was silent. I understand there was a
She filed
scheduling,
a joint report and scheduling order. That takes it off.
but then she did nothing. She did nothing under the
So again,
scheduling
was this
order.
because, and your stipulation, your client's stipulation didn't include it. Was that an intentional act to make sure Shinohara got dismissed? Because under the rules, your client, before an answer is filed, is allowed to dismiss the case with a notice. But once the answer is filed, your client can't just file a notice. Your client has to get the case dismissed in another way. What action did your client take after the answers were filed in the joint report to have the case against Ms. Shinohara affirmatively dismissed? Anything?
My clients took no action to affirmatively dismiss Ms. Shinohara. That was done through orders of the court continuing the matter on the dismissal calendar without any action by Ms. Shinohara to clarify, object, or
You
stop.
just acknowledged a minute ago that she filed the scheduling order, so there was action by Ms. Shinohara.
Yes, but I think the purpose of the 16B scheduling order is to move a case forward. Nothing happened in this case, to Judge Gass's question. There was no activity in this case whatsoever on the part of Ms. Shinohara or my clients. That just went dormant. Deadlines were passed, deadlines were missed.
But that
and-
goes to whether or not your client later could be found to have failed to prosecute and lose. I mean, at the end of the scheduling order, there's a hearing, right? I mean, I tried cases. We come in January 29th, and defendants walk in and you walk in, and the court says, okay, are we ready to go? And your client is going to have to stand there and say, I didn't disclose experts, I didn't do any depositions, I didn't do any discovery, and either go to trial with nothing, or try and get out of the case at that point, or try and get the scheduling order, right? Those are the three options.
I think those are the three options,
Okay.
yes.
So you've got a scheduling order. What were defendants supposed to do with that scheduling order if your client wasn't doing anything? There was no notice of experts. There was no responsive experts needed. There was no disclosure of expert reports. There was no need for responsive experts reports. Defendants don't have to do discovery, at least not until they see what plaintiffs are asking for.
Well,
So I don't understand what you think defendants were supposed to be doing as opposed to when your clients have an active scheduling order, what they should.
I think that we're disagreeing about the general purpose of the rule. And I understand your point, and I think I've answered it. What are defendants supposed to do? They're not just supposed to sit there. They're supposed to say something. And I think that was the point that Judge Thomason was making. You didn't say anything. You didn't tell me, and if you go back and look at the cases that opposing counsel cited in their brief, Gorman and the other cases, those are under the old rule, but in those cases, the parties were affirmatively moving the case forward. In this case, the only thing that was happening was the settlement efforts were continuing as between the settling parties,
They also sent some requests for depositions that your clients ignored.
which they canceled. We did not ignore them. They canceled them. They canceled them.
So something.
Yes, there was a start of discovery, and then it was all stopped. And then they went radio silent. So, go ahead.
Oh, I'm sorry.
I'm sorry, Your Honor.
No, I interrupted you.
What I was going to say is, what I think your question to me is, can a defendant sit and do nothing? If they're looking at orders from a Superior Court judge telling them the matter's going to be dismissed, I think they have an affirmative duty to say something. If they're right, the judge approves, and then we all have guidance. If they're not right, they had guidance and could have acted. But I think the point is, they just didn't do anything.
Don't you have an obligation, the same obligation, to not omit a party that you knew was not on the scheduled for dismissal?
They were not,
You omitted, you had this footnote in there, and then at some point you started omitting that footnote explicitly. Why isn't that just as bad as their failure to say, hey, we think there's been a change from when this originally started, and now we're concerned?
I don't put those in the same footing. The opposing parties, including SHINOHARA.
And I would tell you,
I'm
I
sorry.
agree with you, I wouldn't put them on the same footing either, because one makes me concerned about sharp practice, and the other makes me concerned about inadvertence. So,
Okay, and let's go to sharp practice. We had I think there were 6 total attorneys. There was a group of attorneys that were representing the various parties that were settling, and every stipulation and every order signed by the trial judge were copied to opposing counsel. So I would, might I just finish just 1 second?
Go ahead.
So if the suggestion is sharp practice, then that would be if we hid something. We weren't hiding anything. We were filing and asking for extensions, and court orders were being entered, and they were copied to everyone to complete the answer to Judge Morse.
So if I take your word,
Yes,
then all
thank
you
you,
were doing
Judge.
is extending the original dismissal, then that would not include SHINOHARA. That's all you were doing.
I was advising the court of the status of the settlement efforts
That did
between
not
the
include
defendants.
SHINOHARA.
That did not include SHINOHARA.
So why did your stipulation not exclude her? Because that's where the sharp practice concern comes in. You excluded her expressly, your clients did, and I'm not trying to you personally. Your clients excluded her twice in the first one. Your clients excluded her once in the second one in the footnote, and then that just went away. That doesn't feel right when now it's being used as an affirmative statement that no, SHINOHARA was subject to the dismissal. How do I feel good about that?
I think you feel good about it because SHINOHARA participated in hearings at which time these topics were discussed. That was in March, I believe.
And the
the parties
scheduling
were
order
present.
was put in.
And that is correct.
So that means she's off the dismissal calendar.
And
That's what a scheduling order does.
Okay, and so what?
No, I don't say, that is what the rule says, isn't it?
That is what the rule
Okay,
says.
so she's off the scheduling order.
She is off the
Or
scheduling
off
order.
the dismissal calendar.
I'm sorry, yeah.
I'm sorry.
Because of the scheduling order, she is now off the dismissal calendar. But then there are continuing activities in the case designed at ending the case, and she does nothing.
If
That's
the case
the
was
point.
dismissed on August 14th,
Yes, sir.
what were you continuing in September?
I had a client that there had been a change in some of the settlement terms, and this is disclosed in that motion that we filed. We had a change in some terms, a client that was very ill.
But if the
and-
entire matter had been dismissed, which is your argument that you've been trying to say,
Yeah.
what were you continuing?
I was trying to get it put back. It had already been dismissed, but I was asking to put it
That's not
back.
what you filed. You didn't say, I know it's been dismissed, let me back in. You filed a continuation. That's different.
Okay, I filed a continuation, but the wording of Judge Thomason's order said that I had to give, I'm looking for it, I believe I had to give, there had to be, like, beyond your normal cause, there had to be,
Sure, that was an
absent the most extreme
That was the
situation.
July one. And then
Correct.
you filed a motion to continue, not to get a putback in, you filed a motion to continue.
I did
So if you were out, why would you need it?
because the language of the order says, absent the most extreme situation, the dismissal date will not be continued again. So
After August 14th.
after August 14th, and this
After
was
August 14th, you came back in to continue.
following the language of the order that says, absent the most extreme situation, the dismissal date will not be continued again. I used that language to ask for a continuance. I knew we had passed the August 14 date, but I was presenting.
But you didn't file a motion to reinstate. That's what you should have filed at that point. Wouldn't that be accurate? Because you're saying the case was dismissed on August 14th. That's your client's position.
I was following the order, Your Honor.
No, I'm asking you. The order said it's dismissed. So how are you following the order, following the dismissal, by filing a motion to continue, instead of a motion to reinstate?
perhaps I'm not answering you well, but the wording of this order said that the dismissal date will not be continued again absent the most extreme situation. So I'm sorry, I'm not trying to be difficult. You asked me. I would not have filed a motion to reinstate. I was asking because it said it was already dismissed. So I was trying to get my foothold on the only wording I had to operate from. Otherwise, the case was dismissed. And that's why I did it. Because it says will not be continued again. So I was trying to mirror the wording of the
I can add to
order.
a question. Why was
Yes, sir.
SHINOHARA defeated from the stipulations going forward, as opposed to your client affirmatively filing a motion to dismiss SHINOHARA, which is the appropriate way to move forward?
The stipulations to continue on the inactive calendar, I'm sorry, on the dismissal calendar.
I know.
Yeah, I know, it's,
There was no such thing as an active calendar. There really isn't a dismissal calendar, but
yeah, but it's a new word now. But we were informing the court as to the settling parties. And the first stipulation and order, I think, was done by the defendants, and thereafter, we kept filing to keep the court informed of the status of the settlement side of the case. But the judge entered an order, and it said,
But that's the
continuing
thing.
the matter.
he did exactly what you asked, and your intent was only as to the settling parties, because the stipulations your clients filed didn't exclude SHINOHARA at that point. So why should I conclude
Yes.
that your intent was never to include SHINOHARA, but the court's was, and they should have known?
I think that there's two pieces to that. Number one, the updates were as to our piece of the case, and therefore we were
And so
reporting
the
that.
continuance was only as to that piece of the case.
I
You're
was
continuing a dismissal.
continuing a matter on the dismissal calendar based upon reports regarding a portion of the case.
But you didn't tell the court that it was only as to a portion of the case. Your stipulation didn't include the SHINOHARAs after a certain point. So you had an intent, from what you're saying here today, to not include that. And the form of order the court signed mirrored what you said. So why? Now, do I take this intent that you had, and which could only continue as to those defendants, and apply it to SHINOHARA?
I think that the answer to your question is the update was to our portion of the case. However, it was the entire matter. You're correct, there was a scheduling order, but then he has to do something. They did nothing. The dramedy...
Its only obligation under that scheduling order ultimately was to show up on, I think it was January 29th, to say plaintiffs did not. Plaintiffs have the obligation to pursue the case.
I think I disagree with you. I think plaintiffs and defendants have obligations. This is not a situation in which just one side has a duty to move a case forward. The rules require cases...
If the plaintiff doesn't submit experts, does the defendant have an obligation to submit experts?
If it chooses to have an expert, yes.
Right, if it chooses to, but if a plaintiff doesn't have any, is it unusual that a defendant doesn't have any too?
I've had cases go both ways. I have a case right now
Exactly.
where I'm a
So-
plaintiff and I
so
have an
this-
expert and the other side doesn't.
So in this case, your client didn't disclose any experts and we go to that. I've seen cases go to trial with no discovery, basically. So
Agreed, I have.
So under the scheduling order, if plaintiffs felt something was going on, they could have filed something, but the job was for everyone to show up in January and tell the court what the status was.
See, I think I disagree with you because, Your Honor,
Well, let me ask this.
Go ahead.
How did your clients believe the case was on a dismissal calendar?
Because the judge told us.
Based on an order you filed, based on a stipulation that didn't include SHINOHARA?
Based upon an original placement as to everyone except SHINOHARA,
Right.
and then we filed stipulations, and thereafter, the matter kept being continued.
I'll
You are
take-
correct, there was then an answer.
Let me jump in here, because
Of course.
we're well over time, and I know you're responding to questions, but just take 10 or 15 seconds and wrap it up.
10 or 15 seconds.
It's okay, yeah, it's okay.
Okay, so with 10 or 15 seconds, I haven't got much that I can say. I think the point here is that there was no sharp practice. What there was is a situation in which a defendant just sat back and took no action despite warnings, repeated warnings of signed orders from a Superior Court judge. I understand the suggestion that simply because a scheduling order was put out there, that saves the case. But I disagree. When you have a direct and affirmative order, do you sit back and do nothing? I suggest you don't, because when you do nothing, you get into these kinds of quandaries.
And with that, counsel, I'm going to cut you off. We're probably 2 or 3 minutes over the
Okay.
allotted time, so thank you.
Thank you for giving me my
You bet.
15 seconds.
Thank
I do
you.
appreciate it. And thank you for your good questions.
Thank you. Counsel, you have some time left on rebuttal if you'd like it.
Thank you, Your Honor. I'm going to start with addressing a comment by Judge Morse regarding whether there was no inadvertence here. Clearly there was. And much like a Shakespearean play, this case does have a dark side. Because what we have here is a series...
That was your second Shakespeare reference. You're limited to 3.
Okay. I referenced the same play, Your Honor, so I apologize if I mixed that up. The orders that the plaintiffs in this case are talking about were submitted by them to Judge Thomason without review or stipulation by defendant SHINOHARA. And counsel has gotten up here and argued to you that somehow it is the defendant that has to prosecute a case. A defendant does not have the burden of proof. And at best, counsel's comments that defendant SHINOHARA did nothing are disingenuous. Because when you look at the record in this case, Your Honors, you will see that on March 5th of 2020, you will see that defendant SHINOHARA filed its contribution to the joint report. What is a joint report? By rule, it is supposed to be a joint report by all of the parties. That's not what happened here. It is the plaintiffs who failed to move the case along and respond to requests by defendant SHINOHARA to get the joint report moving to keep the case on the track, I earlier talked about tracks, that this case was supposed to be going. So even by a cursory review of the record, we see that defendant SHINOHARA filed her solo contribution to the joint report on March 5th, 2020, and it's not until 2.5, 3 weeks later that the plaintiffs finally getting around to their contribution to the joint report. And at this point, the trial court issues its scheduling order in this case. And we leave it with, Your Honors, the scheduling order that only applies to defendant SHINOHARA.
I get that your opposing counsel said, might have spoken in that way about the burden on you guys to pursue the action. But what I really am taking from our argument is that it's not so much to pursue the action, but is to speak up when the court errs, or as you're claiming the court erred in this case. So set aside the fact that they had the stipulations and then their stipulations changed over time and quit mentioning Ms. SHINOHARA. If the court had just issued an order saying this matters on the scheduling order, don't you have an obligation to speak up in that case?
We have that addressed in our motion, Your Honor, because when that minute entry arrived, what do? We look at the rules and we look at the record. And the record indicates
I'm positing a hypothetical here that is different than this situation. If there was just an order that said this matter is now placed on the dismissal calendar.
For defendant SHINOHARA, Your Honor, we had clarity. We knew that the plaintiffs and the non-SHINOHARA defendants were fighting for over a year over getting their settlements done, to the extent that I think they were called back to a hearing and the judge had to make some rulings on the motions that only applied to them. We're not privy to that because we were excluded from some of the proceedings because we were not settling defendants. So the issue for us was clear that these did not apply to us. And it's also clear to us that...
I'm positing a hypothetical.
Certainly.
Which is, if the court, without the context here, had said, placing this matter on the dismissal calendar, you have an affirmative obligation to speak up at that point.
I would agree with that, Your Honor, if an order of dismissal appeared. As we've briefed in our case, we have to have an order of dismissal. And if the trial court had issued an order of dismissal, I agree, we would have had to do something to alert the trial court. But an order of dismissal is not self-executing.
What I thought you were going to respond is say, we filed our joint scheduling order, which is what would take you off the dismissal calendar. but you...
Well, if that's a better option, Your Honor.
But you think that it actually your only obligation comes when there's an actual dismissal order?
I apologize, Your Honor, if you could re-ask the question. I'm not sure I followed your question.
Your position is your only obligation to do anything is if there's an actual dismissal order being filed against you?
Well, we had a scheduling order in place, Your Honor, so we did do something. We gave a heads up to the court, we're going to have an impending hearing here, but we need to address some issues. So that's exactly what Defendant SHINOHARA did in this case.
Okay, thank you.
Thank you, Your Honors.
So let me ask you this. I mean, does this come down to whose inadvertence wins? Is it the inadvertence in a sense and the defendants filed or plaintiffs filed something and the court putting everybody on a dismissal calendar when it was not supposed to include SHINOHARA? Or is it, and defendants lose, SHINOHARA loses because she didn't speak up? Or does the inadvertence go the other way, that the court shouldn't have put it on the dismissal calendar, it wasn't allowed by the rules?
I would respectfully say, Your Honor, this was not a case of inadvertence, and this is not a case of whose inadvertence wins. Defendant SHINOHARA was not inadvertent. The record was researched. We looked at the rules. We knew that this did not apply to us based on the litany, and I won't regurgitate it all here. So Defendant SHINOHARA vetted the issue, looked at it, and we understood where the case was, having proceeded through it at the trial court. Thank you, Your Honors.
Okay, counsel, we thank you both for you're finished, correct?
Yes, Your Honor.
You still have 2 minutes. I just
No, I am concluded.
Okay.
Thank you.
Counsel, we thank you both for your arguments and your answers to our questions. We'll take the matter under advisement and issue a written ruling in due course, and we are adjourned.
Thank you.